Please the court, my lady. Morning.
Good morning, my lady.
Nesiwe, please place the matter on record.
Thank you, Judge. Today is the 17th of August, 2022. Calling the matter of Life Esidimeni Inquest, case number I-001 of 2021. Thank you, Judge.
Morning, Judge.
Thank you. There is an application for a postponement by one of the representatives of Dr. Malamela, Mr. Makani. He is seeking a postponement of this inquest until the 4th term. The application is opposed by the majority of the legal representatives of the other parties involved. The reasons for the application are that Dr. Manamela is not ready. She requests an opportunity to prepare herself. In reply to the submissions made in opposition of the application, Mr. Makani mentioned that the court was aware that they had issues of case lines, network, and the fact that there have been a number of amendments to the statements made by the witnesses who testified in the inquest. There were other issues which I will deal with later in the application. I need to give a brief background of what transpired in relation to the dates that have been set for the continuation of the inquest. On the 23rd of May, 2022, I issued a directive which related to the dates for the continuation of this inquest. The directive is always issued after holding a case management meeting with the parties to check their availability. The dates as per the directive are the following. It was the first week 1, from the 18th to the 22nd of July 2022. Week 3, which was from the 1st to the 5th of August 2022. Week 5 to 6, which was from the 15th to the 26th of August 2022. And week 8 to 9, which is from the 5th to the 16th of September 2022. On the 5th of July 2022, I received an email from the legal team of Dr. Selebanu, in particular, his attorneys of record, Ramsey Weber Incorporated, wherein proposals were made pertaining to the dates when the evidence of Dr. Manamela and the former MEC for Health, Ms. Katani Mahlangu, could be heard. Having regard to the evidence that was still being heard at the time, it was proposed that the evidence of Dr. Manamela, who has been scheduled to testify first in the list of witnesses, be heard in the week of the 22nd to the 26th of August 2022, that of Dr. Selebanu in the week of the 5th to the 9th of September 2022, and that of Ms. Mahlangu in the week of the 12th to the 16th of September 2022. Subsequent to receipt of the email, I immediately called for comments through my registrar from the legal teams of the parties, in particular those representing Dr. Manamela and me. Mrs. Mahlangu's legal team responded and raised their concerns, which I do not find it necessary to place on record, as this have been dealt with in the case management meeting. The legal team of Dr. Manamela did not raise any concerns. They agreed with the proposal and further confirmed that they were busy preparing their client. The inquest then proceeded as per the directive on the 18th to the 22nd of July 2022 and on the 15th to the 16th of August 2022. Only yesterday, on the 16th of August 2022, after hearing the evidence of Mrs. Nyatlo, the CEO of CCRC, Mr. Makani addressed the court from the bar requesting an application for a postponement. The legal principles applicable to an application for a postponement are tried. The trial judge has a discretion to grant or refuse a postponement, and the discretion has to be exercised judicially. A postponement will not be granted unless the court is satisfied that it is in the interest of justice to do so. The requirements for a postponement have been stated in a number of cases. One, the applicant has to show that good cause exists for the postponement. The court has to take into account a number of factors when it exercises its discretion to grant or refuse a postponement, which factors include, but not limited to, whether the application has been timeously made, whether the application explanation given by the applicant for the postponement is full and satisfactory, whether there is prejudice to any of the parties, and whether the application is postponed. The Constitutional Court in National Police Service Union and others versus the Minister of Safety and Security and others, 2000, Volume 4, SA 1110, explains the interest of justice as follows at paragraph 5. I quote, "What is in the interest of justice will in turn be determined not only by what is in the interest of the parties themselves, but also by what, in the opinion of the court, is in the public interest. The interest of justice may require that a litigant be granted more time, but account will also be taken of the need to have matters before this court to be finalized without undue delay." Having said that, the court will have to look to whether the application was made timeously. In Mayback Transport versus Buota Trading as Truck Bodies, 1991, Volume 4, All South African Law Reports 574, Namibia NMS, the court held that the application should be made timeously as soon as the circumstances which might justify such an application become known to the applicant. I do not agree that this application was made timeously. As I indicated at the beginning, that the evidence of Dr. Manamela has been scheduled to be heard from the 22nd of August 2022. Given the long duration of this inquest, the fact that the legal representatives of the parties have confirmed their availability on the days set down for this inquest, and that they have other matters to attend to, I do not agree that the application has been made timeously. There was no warning prior to completing the evidence of the two witnesses in this term that there would be an application for a postponement. As I was listening to the submissions by Mr. Makani, he only alerted other parties in the inquest in the morning of yesterday, the 16th of August 2022, that he would seek a postponement. Whether the application given by the applicant, whether the explanation given by the applicant for the postponement is full and satisfactory. It is correct that there were various amendments to the witness statements. Sight should not be lost that Dr. Manamela and her legal team have been present throughout the proceedings to familiarize themselves with the evidence and had cross-examined the same witnesses who amended their statements where necessary. The court has noted the issues of connectivity and case line problems as raised by Mr. Makani. Mr. Sibara previously indicated such problems to the court and subsequently proceeded with the proceedings smoothly. It was only on the 15th of August 2022 when the legal team of Dr. Manamela was asked if they wanted to cross-examine Mrs. Nyatlu, that Mr. Makani indicated that Mr. Sibara had such problems and therefore requested an indulgence to commence his cross-examination at a later stage. That indulgence was granted and he was able to proceed with his cross-examination of the witness. There was another issue that was raised that related to the voluminous nature of the record. Yes, it is true that the record of this inquest is voluminous, and further that a number of counsel have been complaining that the preparation is done as the inquest proceeds. Having regard to this aspect, I conclude that the explanation is satisfactory. As to the issue of prejudice, in my view, the prejudice that the applicant will suffer should the postponement not be granted far outweighs the prejudice that the other parties in the inquest will suffer if the postponement is granted. Having thoroughly considered the application, I am of the view that it is in the interest of justice to grant the postponement. However, I find that the period requested for the postponement of the inquest to the next term and or the date of the week of the 12th of September 2022 is too long. The applicant has more than enough time in a period of more than 2 weeks from today to finalize the preparations. It is only fair to all the parties involved who availed themselves and secured dates in this term for the hearing of the inquest that the matter proceeds in the week of the 5th to the 16th of September 2022. Under the circumstances, the court postpones this hearing to the 5th of September 2022 for the hearing of the evidence of Dr. Manamela.
As the court, please.
As your ladyship pleases.
As the court pleases, my lady. As the court
pleases, my lord. Please, my lady.
May it please the court, my lady.
Nelisiwe, can we then convert this to the case management meeting to finalize the issue of the dates?
Noted, Judge. I'll stop the recording.